Hello everyone. So today we'll be talking about what? So today we'll be talking about basic structure. So if you see the syllabus, always look at your syllabus, because see what happens when you prepare for UPSC or other PSCs also. So you do everything except having a look at your syllabus and previous year questions. So do that. It's very important. So we will talk about basic structure today. What is basic structure? This is topic 1, basic structure. We'll go topic by topic. So like topic 1, features. I'll make some other video on features like parliamentary versus presidential system, FR versus DPSP. We'll do that later on. First of all, this one, basic structure. What is basic structure? As the name suggests, basic structure. There are certain portions in our constitution which are very basic, which are the core attributes, of our constitution. And if parliament, that is the legislature of our country, if they if they change those features now, which are the core attributes of our constitution, it will change the whole meaning of the constitution. That's why judiciary came up with basic structure. Who came up with basic structure? Judiciary came up with basic structure. No mention of this BS. BS also means bullshit, so don't write BS. That's I am doing for my own purpose. So BS is an abbreviation for basic structure. Don't use these WhatsApp lingo in your mains answer. This is WhatsApp lingo. So avoid this. So, but again, I can do whatever I want to do, but you shouldn't. So no mention in constitution. Do remember, this is a judicial innovation. This is also called as judicial activism. That at that time, what is happening? Let's understand it. I will show you so many things, so don't worry about it. We'll go slow. So what is basic structure? The meaning here is there are certain portions and there are certain parts of our constitution which are the core attributes. If parliament changes these core attributes, the whole meaning of the constitution will change. So that's why judiciary in Keshavananda Bharati versus state of Kerala, in that particular case, this one, Keshavananda Bharati versus state of Kerala, they came up with this basic structure, that parliament cannot amend certain portions of our constitution, right? This is the basic thing. There's no exact definition, right? Because this is not there in constitution. This is judicial innovation, right? So there is no exact definition of basic structure. Mainly certain, what is the basic meaning of basic structure? That there are certain features of constitution which cannot be amended by legislature, which in this scenario is parliament. Now there are three things: legislature, executive, and judiciary. So what does legislature do? They make laws. What does executive do? Legislature means parliament or your state legislature. Executive is PM, CM, and not only them, even you people, when you become a civil servant, you are also executive. So executive are two types: political executive and permanent executive, right? Political executive, permanent executive. So these guys, PM, CM, Modi ji, Hemanta Biswa Sarma sir, other people, they are political executive, right? They're there for 5 years. Permanent executive, you people, civil servants, they are permanent executive. It's not like you're there for 5 years. You will be there for a long period of time. So these guys, what they do, executive, what they do, they implement laws. Executive implement laws. Judiciary, they review laws, whether laws are made according to the provision of constitution or not. Fine. So this is basic structure. Certain portions of constitution cannot be amended by parliament, that is the legislature, as they are the core attribute. One thing they can give you in prelims also, that basic structure is defined in constitution. That is wrong. That is BS. That is bullshit. No, it is not defined. Right. Then what is basic structure? What are the different attributes? So what you have to understand here is this BS thing is still evolving. Still evolving. That means there are various Supreme Court judgments. There are various judgments which comes from Supreme Court, and they keep on adding stuff to basic structure. Like judicial review is a part of basic structure. What is judicial review? The power of judiciary to review the constitutionality of laws as well as executive orders. That means whether all the laws which parliament is making, state legislature is making, they are according to the constitution or not, right? So judicial review is one part of basic structure. Other, like parliamentary system, I'll make a separate video distinguishing between parliamentary and presidential system, because many people have confusion there. Many people feel like parliamentary system, PM is the head; presidential system, president is the head. That is not the case here. In parliamentary system, that is just a consequence. The basic core meaning of parliamentary system is here executive is part of legislature. Executive is responsible to legislature. right? And in the presidential system, executive is not part of legislature, not responsible to legislature. Like in simple terms, if you want to understand it, Modi ji, and like Modi ji is what? He's a part of parliament. It's not like there is a separate election, but Modi ji, if you talk about Modi sir, he is what? He's both. He's executive also. He's PM, executive. He's also legislature. He's a part of parliament also, right? Representing Banaras. So he is both. So it's not like there is separate election for Modi sir for executive and legislature. There was one election for legislature, Lok Sabha ka election hua, that happened, and he was elected. And in that Lok Sabha, in that parliament, whoever has the majority, they become the executive. So this is the thing. Here in parliamentary system, executive is part of legislature. In the case of, if you talk about US, Trump, Biden. So Biden is a part of executive. He's not a part of legislature. So there they have two separate elections, one for executive and one for legislature. So this is the main difference between parliamentary and presidential. We'll talk about it. We'll see some questions when I make the next video on this. Very important part. Most of the people make mistake here, and UPSC has asked a lot of question in this particular portion or from this particular portion. So what we are doing here, what we are talking about, or what we were talking about. So these are the parts which are basic structure, supremacy of constitution. There's another provision which is there in basic structure. And why I have shown here Sachin's surface, can you guess? I will tell you in just a minute. So there is another part, or there is another feature which is part of supremacy of, like, which is part of basic structure, that is supremacy of constitution. Supremacy of constitution. What is supremacy of constitution? So see, understand one thing. In India, we have a written constitution. India, we have a written constitution. And parliament, whenever they're making laws, they have to conform to this constitution. They cannot make anything which is unconstitutional in nature. They cannot make any laws which are unconstitutional in nature. But when we talk about UK, they have unwritten constitution. UK have unwritten constitution. So there, parliamentary sovereignty is there. There is parliamentary supremacy in UK. Hope you can understand this. Because there is no written constitution, so parliament is supreme there. They can make any and every law, whatever they want to, although they follow certain caveats, but hope you're understanding what I'm trying to tell you. So supremacy of constitution, according to Supreme Court judgment, that is also part of basic structure. So now, let's talk some more about basic structure. Keshavananda Bharati versus State of Kerala, that in this particular case, Supreme Court came up with basic structure, right? And this judgment, why I have written or shown Sachin Tendulkar face here is, this judgment came on 24th April, 1973. And the same day is the birthday of Sachin sir. So this is easier for you to remember stuff. So that's why Sachin sir face is there. Now, there is another part here which you have to understand. Most of the people now, when they will talk about basic structure, they will just focus on Keshavananda Bharati, and then they will get minimal marks, right? You don't have to do that. You have to talk about the evolution. How come this talk came? That what is the core attribute of the constitution? What is not the core attribute, etc., etc. There has to be some things which were happening behind the picture. So this all started with one topic, and that topic was whether FR can be amended or not. Whether FR can be amended or not. What is FR? Fundamental rights. So we all have some fundamental rights, right to equality, right to freedom of religion, all these things, protection against untouchability, all these things, right to freedom of religion, cultural and educational rights, constitutional remedies, all these are fundamental rights. So the question was, this was the basic question from which everything started, whether FR can be amended or not. So Shankari Prasad case 1951, they said that Parliament can amend FRs. Parliament can amend FRs. Can amend FRs. Then Golaknath case 16 years after, they said, no, sir, you cannot amend FRs. Fundamental rights are very absolute. So cannot amend fundamental rights. You cannot amend fundamental rights. Then Keshavananda Bharati case came. They said that FR can be amended. Fundamental rights can be amended. But only those FRs. But only those FRs which are not part of basic structure. Hope you can understand. But only those FRs can be amended which are not part of BS. Which are not part of BS. Not part of BS. That means which are not part of basic structure, only those fundamental rights can be amended. Then Minerva Mills case. Hope you can understand. This is the Keshavananda and Bharati judgment. So the whole discussion was about whether FR can be amended or not. Shankari said, Shankari Prasad sir case said that they can amend the FRs. Parliament can amend. They can change fundamental rights. Golaknath, no. Keshavananda said, yes, you can amend, but only those FRs which are not part of basic structure, because those FRs which are part of basic structure, they are the core attributes. You cannot change it, otherwise it will change the whole meaning of the Constitution. Minerva Mills case, 1980. They said that there's one Article 368. Can you guess what is Article 368? Just a second, man. Oh my God, my nose is gone. So yes, what is Article 368? Article 368 is talking about the amending power of Parliament. Like Parliament is changing Constitution, right? If you see this here, and do have a Constitution with you, one in hard copy format, one in soft copy format, and one as an app. There is also an app, Constitution app. You can find it on Google. So they will give you one article every day. So that way you can also revise stuff. So see here 368. So we know Parliament can amend Constitution. They can change Constitution. This power is there in 368, Article 368. So what Minerva Mills case was saying that this power under Article 368, power under Article 368 is limited. Limited means whatever amending power you have been given under 368, it does not mean you can amend anything and everything under the Constitution. This power to amend the Constitution is limited, sir and ma'am, and it is not absolute. So this was one thing which Minerva Mills said. The other thing which Minerva Mills said was judicial review. It is also part of basic structure. We're continuously talking about judicial review. As we know, what happened? There were various judgments which came one after the other, and they keep on adding things to BS. That is basic structure, not. Okay. So hope you understand this. So judicial review is part of basic structure that Minerva Mills case said. And so many other judgments came and they're still coming. So that's why it is said that basic structure is still evolving. It is not a constant phenomena. Other judgments will come which will add certain more stuff to basic structure. So what we are talking about? So judicial review, part of basic structure. What happened in Waman Rao case then? So they said that this BS thing, this BS, that is basic structure, would apply to all amendments, after such and such birthday. After such and such birthday. Why? Why it will apply to all amendment after such and such birthday only? Because if you do remember what we talked about in the previous slide when we were showing you this, that such and such birthday, Keshavananda Bharati judgment came. So they are saying that this basic structure phenomena would apply to all amendments, which is done after the Keshavananda Bharati judgment. Fine. So BS thing, it is still evolving. And what you have to also understand here is, that Supreme Court will come up with judgment and they will keep on adding stuff. So hope you can understand what is basic structure. Now there are certain things here which you need to understand. And those things are, what are the criticism? What are the criticism of this basic structure thing? I will show you, don't worry. You can always pause the video, you can write down these points. I will also show you my handwritten notes where I've written all these points so you can have a look at it again. So criticism part also, now, because you're preparing for UPSC, you're not preparing for any, like, all exams are sacred, but I'm just saying that here you have to write both the things, good things and bad things. So what are the bad things? We have talked about the good things. This is actually good. BS is good. Basic structure is good because they're talking about the core attributes. Criticism is, there's a constitutional expert whose name is Subhas Kashyap sir. If you listen to All India Radio, he comes a lot on All India Radio 9 p.m. telecast and broadcast. So he said that, Subhas Kashyap said that, if we are saying that there are certain portions of our constitution which are basic in nature, then what are you trying to say? That other parts are non-basic. Others are non-basic. What is the basic meaning? What do you want to say here? Others are non-basic. They're not important. Only these parts are important. So this is one criticism, which was told by Subhas Kashyap sir. Then there was one Hindu article. I will show you that article as well. So in that Hindu article, they were saying that this is nowhere there. BS is nowhere in Constitution. It is not there in Constitution. It is a judicial innovation. It is judicial activism. So in a way, you can also say that judiciary is imposing. Who makes laws? What we have discussed up until now. The law making thing, that is a prerogative of whom? Legislature, executive, or judiciary? Legislature. Na? So these kind of things, if it has to be made, it has to be made by legislature, not judiciary. Judiciary can only review laws. So according to that Hindu article, in this particular thing, when BS is happening, it is actually a way of judiciary imposing their philosophy. Judiciary imposing their philosophy over democratically elected government. They cannot do that. Now, the government which has been elected by us, they will make laws, not judiciary. So this leads to something known as tyranny of unelected. This leads to something known as tyranny of unelected. So that's what they are saying. So judiciary imposing philosophy over democratic elected government, which leads to something known as tyranny of unelected. But again, the conclusion, the good things is why you need BS, why we need BS. What can you think of the reasons? First thing first, why we need BS. And this will be your conclusion part. Needed to keep majoritarian government in check. Let's say there is a government needed to keep majoritarian government in check. Majoritarian government in check. So what is the meaning here? The meaning is, let's say there is a government which has too much majority. They can pass any law in parliament, right? So they will change the whole constitution, right? They can curtail your fundamental rights, etc., etc. Basic structure ensures that that does not happen. So it is needed to keep majoritarian government in check. What else you can say? It also prevents, what does it prevent? It prevents sovereign democratic republic from becoming a totalitarian regime. Prevents, this is the second point, prevents sovereign, independent. Sovereign means independent, democratically means elected by us. Sovereign democratic republic. Republic means the head of our country is a elected head. Monarchy, there is a nominated head. So prevent sovereign democratic republic from becoming a totalitarian regime. Because then if there is no control over their amending power, they can amend anything they want to, and they will not listen to anyone and everyone. So it will become a totalitarian regime. It will become a dictatorship. So this is why you need basic structure. Fine, I will show you some notes. Before that, there's one question. We were continuously talking about judicial review. See this question. And then I will show you the notes, and then your basic structure part is done. And you can write good answers on basic structure part. So let me erase this. What do you think is the answer of this question? What is judicial review? Because I've just told you when we're talking about the evolution of basic structure, that in Minerva Mills case, they said judicial review is a part of basic structure. So what, according to you, is the answer of this particular question? You can pause the video so that I don't ruin the question for you. So judicial review is power of judiciary to pronounce upon the constitutionality of laws and executive orders. So here in governance now, in polity, you have to be very, very aware what they are framing. Like judiciary can do this also, D part also, but this is not known as judicial review. Judicial review is when they are seeing the constitutionality of laws as well as executive orders. So they are seeing the laws and the new law has been framed. They will compare it with the constitution. If it is unconstitutional, they will strike it down. Power of courts to determine the validity of acts. So now let me show you what I was talking about. So we were talking about this, and let me make it bigger because it's handwritten, right? See this. So Keshavananda Bharati judgment, no exact definition. What I've told you, there's no exact definition, man, because this is not there in constitution. It is still evolving. The main aim, what is the main aim? To put a limitation on amending powers. And amending power of parliament is under which? Article 368. And they are the fundamental provisions which are inherently important to safeguard the spirit of constitution. We have just discussed what are basic structure. It is continuously evolving. Judiciary in their various judgments have added certain things like parliamentary system, independence of judiciary, separation of power, judicial review, etc. Then we have talked about this evolution thing. If you see this evolution thing, different cases, Golaknath case, Shankari Prasad case, from where this whole thing came. Do you remember this SGK MW? Shankari Prasad, Golaknath, Keshavananda Bharati, Minerva Mills, and Waman Rao. Shankari Prasad, they said that Parliament can amend. Golaknath, no, cannot amend. Keshavananda Bharati can amend, but only those which are not part of basic structure. Minerva Mills, 368 is limited. Amending power, if a Parliament is limited, they cannot amend anything and everything under the judicial review basic structure. Waman Rao, every amendment after Keshavananda Bharati or Sachin Sir's birthday will be checked under the doctrine of basic structure. It is still evolving, and subsequent judgment judiciary has further extended the scope. Then we have talked about the criticism part. That Subhas Kashyap, there is a constitutional expert, Subhas Kashyap sir, he said that delineation of basic structure, does delineation of basic structure mean other parts of constitutions are non-basic? So this is a very good point actually, whatever was raised by him. Then there is another thing. there was one Hindu article which I have written down. The basic meaning here is of this Hindu article is that there are some people who says that it is not there in constitution. So it is in a way, what they are trying to do is they are trying to impose tyranny of unelected, impose their philosophy. Who is imposing their philosophy? Judiciary is imposing their philosophy over the legislature. So that should not be done. So, but again, if you can, again, just a second. If you see this whole article, if you want, you can even have a look at it. The date also I've written on this page. 4 to 19, 2019, 4th February. So these articles are actually very good. Just a second. Oh God. Okay. So the basic meaning of this article was that, no, you need it. Although it was not there, and you can say there is tyranny of unelected, but what happens is, if the power of parliament is not kept in check, and if we don't say that Article 368 is limited, then the power of parliament will become infinite, and they can do anything and everything. They can remove, and what you can say, they can abrogate or they can minimize your fundamental rights, etc., etc. So we have talked about this. So that's why you need basic structure to keep majoritarian government in check. So that's what it is actually, and we have discussed anything and everything which you need to know about basic structure. Hopefully you find this particular thing interesting, and that is it, I guess, for this particular video. Do revise it, do go through it, and this will help you a lot in writing answers on basic structure, because anyway this is there in your syllabus and this is there in bold letters. Not bold letters, I am making it bold for you. Basic structure. So yeah, that's it. Take care, be blessed, bye bye.